Hey everybody, we're talking about how all courts are United Nations courts with Baal priests in them. And so let's get going. Um, this is the International Covenant on Civil and Political Rights, Article 1, Clause 1 and Clause 3. And it says all peoples have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. And then Article 3, it says the state parties to the present covenant, including those having responsibility for the administration of non-self-governing and trust territories, shall promote the realization of the right of self-determination and shall respect that right in conformity with the provisions of the Charter of the United Nations. And the interesting thing here is, I want to point out, is it says here all peoples, and this covenant between these nations is all it talks about. It uses persons, it uses all people, it uses everyone, depending on the clause and the article. And so and these people that put this together are liars, and so they know exactly what they're doing. They know which words to use under what circumstances and all the rest of it. It's calculated. Every word is calculated, I guarantee you. Anyways, the point, another point I want to make is that this is all Roman law, which is controlled by the Roman cult. And this is Article 2, Clause 1. Each state party to the present covenant undertakes to respect and to ensure all the individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Okay, status is definitely Roman law. Common law status means nothing. Under Roman law, status means everything. And so again, and this is all discrimination. This is all found in that's they passed a bunch of statutes on that in their color of law statutes. And as we go through this, you'll see that they can just throw all that stuff out the window if they feel like it. And I mean, you see them creating false flag operations and stuff. And there's an emergency. We need to throw all your rights out the window. You know, that's exactly what they do. Anytime they're talking about status, it's Roman law. An example of political status is the status of being a state citizen rather than being a U.S. citizen. And this is the foundation of all statutes against discrimination. It's all coming from the UN. And these Baal priests are busy enforcing this stuff. This is Article 2, Clause 2. We're not already provided for by existing legislative or other measures. Each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional processes and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. Okay, so they're basically saying that all the states have to adopt measures, okay, of course within their constitutional limitations, and because otherwise the treaty would be unconstitutional, okay. The covenant would be unconstitutional. And so, anyways, and then in Article 2, Clause 3, it talks about each state party to the present covenant undertakes to ensure that any person, okay, so now they're talking about persons, okay, whose rights or freedoms are as herein recognized or violated shall have an effective remedy, notwithstanding that the violation is committed by persons acting in an official capacity. So looks to me like they're talking about government employees. And that's just the same as the U.S., okay? That's the same as anywhere, government employees. To ensure any person claiming such a remedy shall have his right thereto determined by a competent judicial, administrative, or legislative authorities. Actually, they're administrative or legislative. They're actually legislative and administrative. Or by other competent authority provided for by legal system of the state, to develop the possibilities of a judicial remedy and to ensure that the competent authority shall enforce such remedy when granted. In other words, it doesn't do them any good to have a remedy if you can't enforce it. This is Article 3. The state parties of the present covenant undertake to ensure all the equal right of men and women to the enjoyment of all civil and political rights as set forth in the present covenant. So Now they get to assault women. Now, basically, at common law, the woman is the property of the husband. Actually, they're both property of each other. And so, but the husband is usually the one that defends everything. And the woman, they tend to be more timid, where the guy tends to have the testosterone and wants to get up in their face. And so it's kind of natural for that to happen. Anyways, and so they like to, it's basically like bullies, eh? They like to go out and pick on anybody and everybody, okay, and assault you, and if you don't, if you just cave into it, then you consented, okay? That's the Roman cult again, okay? At common law, the wife and children are property of the husband and father. It's, however, true that in all common law countries, and has always and consistently been held, that the wife and minor children take the nationality of the husband and father. That's common law doctrine. And the International Covenant on Civil and Political Rights eliminates common law. Okay, it's all martial law is what it is, actually. International Covenant on Article 4. And this is where they can just throw it all out the window. In times of public emergency that threatens the life of the nation, oh man, all these false flag attacks and all these terrorists that are actually government officials, you know, we got to take away your rights. And the existence of which is officially proclaimed, the state parties to the present covenant may take measures derogating from their obligations under the present covenant. And so, again, so they can just throw it all out the window. Everyone, and this is Article 16. And this is the big one that ties everybody everybody into it. And everyone shall have the right to recognition everywhere as a person, okay? So they get to assault you with their person, with their Roman Cult CESTUI QUE Trust. That's exactly what they do. And this is Article 16 of the International Covenant on Civil and Political Rights. And then Article 18, now it talks about everyone shall have the right to freedom of thought, conscience, and religion. Well, what happens if you don't want to participate in their Roman Cult CESTUI QUE Trust? If I have the freedom of religion, I don't want to be involved in their Roman Cult CESTUI QUE Trust, and yet they're going to assault me with their person. No one shall be subject to coercion, which would impair his freedom to have or adopt a religion or belief of his choice. These Satanists, you know, they're nothing but a bunch of Satanist criminals. They're the lowest form of life there is, and they need to be exterminated. This International Covenant on Civil and Political Rights is nothing but smoke and mirrors. And this is Article 8, Article 18, paragraphs 1 and 2. And then paragraphs, or I should say clauses 3 and 4. And then it goes in, it says, and this is the freedom to manifest one's religion or beliefs may be subject only to such limitations. Okay, so now they go and throw in all these little have to and wherefores and all this other garbage that they can just throw it all out the window. The state parties undertake to have respect for the liberty of parents. Now they're bringing in children here. And when applicable, legal guardians to ensure religious and moral education of their children. So no matter how nice they make their United Nations International Covenant, they always insert an escape clause. And it's all Roman law, so it's civil law, and it's not half as good as common law. Common law trumps it head and shoulders, way above it. Common law rights are unalienable, cannot be alienated under any circumstances. With their false flags and their agent provocateurs and their bankster thieves, it's easy to create any sort of emergency they want to justify the denial of privileges that they're calling rights. That's exactly what these Satanists do. Article 19. Everyone shall have the right to hold opinions without interference. And then everyone shall have the right to freedom of expression, a right to include freedom to seek, receive, impart information, ideas of all kind, regardless of frontiers, either orally in writing or in print, in the form of art, or through any other media. Okay, so freedom of speech, and then they go and throw in all their little clauses saying we can throw it out the windows if we want to. It may therefore, in clause 3, it may therefore be subject to certain restrictions, and so, again, these are Satanists, okay? They want you to think that you're getting something special here, and it's worse. It's a piece of crap is what it is. Anyways, coming up with a little advertisement now, announcing a subscription to a subscription-based YouTube channel called Sovereignty International. I've come out with a new YouTube channel called Sovereignty International. The recommended cost of the subscription is currently at $1.99 because it avoids the advertising only. When I first came up with this, I was going to have some exclusive content, and then I started thinking about it, and there's nothing on there that I don't want to have available to anybody and everybody. The only power that these New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it all. And so I can't think of anything that I want on it that would be exclusive. And so I'm currently publishing, actually, I just, this week and next week, it's going to be 5 videos a week. And so if I can give me ideas on stuff you want me to publish, and I'll keep it at 5 a week, and I'll even raise it if I can, come up with ideas on stuff to publish that that people are interested in. But it's currently at $1.99 a month. That's $1.99 a month, which is not much, and I could certainly use the donations too. So I mean, you could just consider it a donation, and you get rid of the advertising. Anyways, something to think about. Now, back to the original topic at hand, the International Covenant on Civil and Political Rights, Article 26. And now it's talking about persons. All persons are equal before the law and entitled without any discrimination to equal protection of the law. Okay, and so, again, this is all Roman cult civil law, Roman law, and it's all the same stuff. They're talking about status, talking about birth, national and discrimination. This is all going back to Roman law, and you can see, that they passed all sorts of statutes that incorporate these things, and the Baal priests in the courts go ahead and follow this stuff like it's again. It's all based on presumption, okay? And so you have to defeat their presumptions. And so the key is to tell them that this stuff doesn't apply. And why? Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, and to distinguish it from law of nature and from international law. Well, think about it, okay? The cities established this law for itself. Well, then that means it's for government employees, and that fits. And so that's Black's Law Dictionary, 4th edition. All of these statutes about anything related to the International Covenant on Civil and Political Rights are a cheap imitation of common law, and that essentially convert rights into privileges. And by this means, citizens' birthrights become of no effect, and their rights are reduced to the inferior character of statutory civil rights, mere legislative privileges. And that's taken from the non-ratification of the 14th Amendment in the case Diet versus Turner, and which is written by Judge H. Ellett of the Utah Supreme Court. At common law, they are absolute rights. Statutes can and are changed. Statutes are just ignored by these Baal priests if they feel like it. History is clear that the first 10 amendments to the Constitution were adopted to secure certain common law rights of the people against invasion by the federal government. And that's Bell versus Hood. Every citizen and freeman is endowed with certain rights and privileges to enjoy which no written law or statute is required. Common law rights are not even written anywhere. You have absolute rights. They're unlimited rights. They're rights for everything as long as you don't damage someone's person or their property. These are fundamental or natural rights recognized among all free people. The people are sovereign, are not bound by general words and statutes restrictive of prerogative, right, title, or interest unless expressly named. Acts of limitation do not bind the king or the people. The people have been ceded all the rights of the king, the former sovereign. And that's People versus Herkimer, a New York court case. In any action in their kangaroo courts, you're going to have to bring up the issue of the International Covenant on Civil and Political Rights and how you're claiming nothing under it, and they have no authority to assault you with it. All of their courts are Admiralty, where the so-called judges have bought and paid for a clerk, and he's sitting there playing stupid. And if you don't say it, then it won't be said. They are Roman Cult BAAL Priests and will assault you with their UN treaties if you don't bring up the issue. And you could even bring up Article 15. Article 15 says no one shall be held guilty of any criminal offense on account of any act or omission which did not constitute a criminal offense under national or international law at the time when it was committed. And that's basically, that's an ex post facto law. And then they go and throw in their little clause, their escape clause here, clause 2, right? Nothing in this article shall prejudice the trial and punishment of any person for any act or omission which at the time when it was committed was criminal according to the general principles of law recognized by the community of nations. And that's Article 15. See, these Satanists have to go and throw that stuff in, and if people aren't aware of it, they just get railroaded. Populate their prisons, make all sorts of money for their bankster thieves. The International Covenant on Civil and Political Rights is nothing more than a make-work project for Satanists. The Satanist order follower, Leos, go out and assault you, kidnap you, and falsely imprison you. The Satanist Baal Priest clerks masquerading as judges get to deal with it in their kangaroo courts. The Satanist order followers in the prisons get to generate revenue with their commercial prisons. The Satanist Baal Priests get to break up families with their divorce courts. The Satanist Child Protective Services gets to steal the children of the victims who are now in their commercial prisons. The Satanist Baal Priest clerks masquerading as judges get to deal with the juvenile delinquents that are created by CPS. The Satanist Baal Priest clerks masquerading as judges get to deal with the juvenile delinquents that become adult lifetime criminals. The whole satanic system forces people into their government welfare system. The only reason you'd ever mention the International Covenant on Civil and Political Rights is to say that in the District of Columbia and the Territories, it is their requirement, not yours. And this is Article U.S. Constitution, Article 1, Section 8, Clause 17, to exercise exclusive jurisdiction in all cases whatsoever over such district not exceeding 10 miles square, may by cession of particular states and the acceptance of Congress become the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. And so, again, the only place that they have legitimate authority is in the D.C., in the territories, and in places that are purchased by the that are seated by the state. Okay, it has to be seated by the legislature. Did you know that there's no place in Texas that was ceded to the federal government? That's true. There's not anywhere in Texas that was ceded to the federal government. Now, they have courthouses and they got military bases, but those weren't ceded by the legislature. Okay. So what they do is they basically bought the land, but it wasn't ceded. The legislature has to pass an act, okay, to cede it. Anyways, this is an act to establish a code of law for the District of Columbia, and it says 31 Stat 1432, Section 56, Chapter 56, Section 1617, the legal estate to be the CESTUI QUE Trust. In the 1800s, a trust was called a use, which is short for usufruct under the Roman law. And this is Tomlin's Law Dictionary, 1835 edition, Volume 2, under the definition of mort main. Yet still it was found difficult to set bounds to ecclesiastical ingenuity, for when they were driven out of all their former holes, they devised a new method of conveyance by which the lands were granted, not to themselves directly, but to nominal fiefs, to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits, while a season of the land remained in the nominal fief, who was held by the courts of equity Then, under the direction of the clergy, well, gee, has that changed? I doubt it. As a matter of fact, I know it hasn't. To be bound in conscience to account for his CESTUI use for the rents and emoluments of the estate. Well, gee, that sounds like taxes. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. In 1835, the CESTUI QUE Trust was the foundation of modern conveyancing. Do you think anything's changed? Absolutely not. The CESTUI QUE Trust is a creation of the Roman Cult. That's another thing that site says. In 1835, the courts of equity were run by the Roman Cult. They're still run by the Roman Cult. The Roman Cult wanted to make sure they get their rents and emoluments, extortion, taxes for their owned and operated CESTUI QUE Trust. When Congress passes an act to establish a code of law for the District of Columbia, and it says the legal estate to be in the CESTUI QUE use, they're essentially saying the Roman Cult owns the United States. Every taxpayer is a CESTUI QUE Trust, having sufficient interest in preventing the abuse of the trust to be recognized in the field of the court's prerogative jurisdiction, and that's Henry Boland's 1912. And then there's a cite from this is a summary from 5 pages of the Congressional Record dated June 13th, 1967. A citizen of the United States is a civilly dead entity operating as a co-trustee and co-beneficiary of the Public Charitable Trust, the Constructive CESTUI QUE Trust of the U.S. Inc. under the 14th Amendment, which upholds the debt of USA and U.S. Inc. It might be correctly said there is no such thing as a citizen of the United States. A citizen of any one of the states of the Union is held to be and called a citizen of the United States, although technically and abstractly there is no such thing. The privileges and immunities as citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. U.S. Supreme Court. The only absolute and unqualified right of a United States citizen is to residence within the territories of the territorial boundaries of the United States. Citizenship is a political status and may be defined and privilege limited by Congress. The term resident and citizen of the United States is distinguished from a citizen of one of the several states in that the former is a special class of citizen created by Congress. It's impossible to prove jurisdiction exists absent a substantial nexus with the state, such as a voluntary subscription to a license, a contract. All jurisdictional facts supporting claim that supposed jurisdiction exists must appear on the record of the court, U.S. Supreme Court. And this is where this stuff is codified. Whoever falsely and willfully represents himself to be a citizen of the United States shall be fined under this title or imprisoned not more than 3 years or both. So now this gives them the right to presume that just because you happen to have a U.S. passport, you're one of their slaves. That's exactly the purpose of that one. The term individual means a citizen of the United States or an alien lawfully admitted for permanent residence. The term federal personnel means officers, employees of the government of the United States, member for the uniform and service, include members of the reserve components, individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States, including survivor benefits. And so what that says is that anybody with a Social Security number is federal personnel. Well, a Social Security number is a number for a CESTUI QUE Trust. And when I went to the Supreme Court the first time, I submitted an affidavit stating that I don't have a Social Security number. I've never had a Social Security number. It's not yours. When you go and say that it is, you just entered into a contract. That's right there. You just volunteered. That's exactly what you did. The term citizen of the United States is analogous to the term subject in the common law. Include, or the participial form thereof, is defined to comprise within, to hold, to contain, enclose, comprise, involve, embrace. That's Montello Salt versus Utah, U.S. Supreme Court. Include in American Dictionary of English Language, Noah Webster, 1828. Include, to confine within, to hold, to contain, as the shell of a nut includes a kernel. A pearl is included in a shell. Include in Black's Law Dictionary, 6th edition. To define, to confine within, hold as an enclosure, take in, attain, shut up, contain, enclose. And then there's the justum generis of the same kind, class, or nature in the construction of laws, wills, and other instruments. The justum generis rule is that where general words follow an enumeration of persons or things by words of a particular and specific meaning, such general words are not to be construed in their widest extent, but are to be held as applying only to persons or things of the same general kind or class as those specifically mentioned. Example: if a law refers to automobiles, trucks, tractors, motorcycles, or other motor-powered vehicles, vehicles would not include airplanes, since the list was land-based transportation. And that's Black's Law Dictionary, 4th edition, page 608. Justum generis, Black's 8th edition. A canon of construction, that means a maxim of law, that when a general word or phrase follows a list of specifics, the general word will be interpreted to include only the items of the same type as those listed. For example, in the phrase horses, cattle, sheep, pigs, goats, or any other farm animal, the general language or any other farm animal, despite its seeming breadth, would probably held to include four-legged hoofed mammals typically found on farms, and thus would exclude chickens. And so, this is a U.S. citizen is not entitled to an Article 3 court, but instead gets an Article 1 court with a plenary military dictatorship. And the reason, before we get into this, the reason we mention justum generis and include is because if you go back here, the federal term federal personnel means, okay, including members of the reserve components, and the term individual means, and so in these statutes, it's limiting, okay, and it's only what's there. It's not something that's not there. A U.S. citizen is not entitled to an Article 3 court, but instead gets an Article 1 court with a plenary military dictatorship jurisdiction. In Article 1, Section 8, Clause 17, Constitution for the United States of America, as defined and reinstated in National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, which further states that citizens of the District of Columbia are not embraced by the judicial power under Article 3 of the Constitution for the United States of America. The same statement in Hepburn versus Dundas. In 1804, the Supreme Court, through Chief Justice Marshall, held that a citizen of the District of Columbia was not a citizen of a state. We therefore decline to overrule the opinion of Chief Justice Marshall. We hold that the District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district and those of the states are not included in the catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power, military dictatorship, people, nationally covers those citizens even in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. It's called the Commerce Clause. National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, U.S. Supreme Court, 1948. And this is where it's codified at 26 U.S.C. 7701-39 or 26 U.S.C. 7408C. It was revised and changed, and so it's one or the other. I can't remember. If any citizen or resident of the United States does not reside in and is not found in any United States judicial district, such citizen or resident shall be treated as residing in the District of Columbia for purposes of any provision of this title to jurisdiction of courts and enforcement of summons. And an act. This is the act to enact the Uniform Commercial Code for the District of Columbia and for other purposes. That's located at 77 Stat 630, Public Law 88-243, and the United States is located in the District of Columbia. So what they're saying is that a U.S. citizen is a D.C. citizen. Uniform Commercial Code, Section 9.307. And this is a citation where I went and filed a lawsuit against somebody in Texas. And look at that. It's got citation written all over it. And it's got CESTUI QUE Trusts all over it. And notice the all block capital letters. Those are CESTUI QUE Trusts. And look at that. A traffic citation. Okay, that's all coming from the Roman Cult. And there we go. A traffic ticket, a traffic citation. That's how these Satanists work. And information, okay, that's all Admiralty. It's under their Admiralty, their martial law jurisdiction. Informations are filed in the Court of Exchequer for forfeiture upon seizure of property, for breach of the laws of revenue, impost, navigation, and trade. And look at that. Admiralty and Commerce, Kent's Commentaries, Lecture 17. And information is a written accusation of a crime made by a U.S. attorney or liar, which permits the government to prosecute an individual without benefit of a grand jury indictment. An indictment is required in any case where a person is being charged with an infamous crime. The Supreme Court ruled in Macon versus United States that any crime for which punishment is imprisonment is an infamous crime. In short, prosecutions by information have long been a means of political suppression and intimidation. The use of information has a long history. For example, in the reign of Henry VII, a very oppressive use was made of them for something more than a century, so as to continually harass and shamefully enrich the crown pigs. And that's taken from Blackstone's Commentaries, Book 4. The oppressive use of this mode of prosecution by information occasions struggles to procure a declaration of its illegality. Well, it's not illegal anymore, is it? The right to be represented exists only in a military courtroom. This is Title 10, United States Code, Section 838A1. The accused has the right to be represented in his defense before a general or special court-martial or at an investigation under Section 832. And so you get a bar member, one of their Satanist baal priests. And he is, however, a sensitive officer of the state with an obligation to the court. And that's found in Book 7, Corpus Juris Secundum, Section 4, on attorneys. His first duty is to the courts and not to the public. It's a kangaroo court and not to the client. And whenever his duties to his client conflict with those as an officer of the court in the administration of justice, the former must yield to the latter. In other words, he's got to conspire with the clerk, the whore on the bench, and railroad you. That's exactly what they do. Clients are also called wards of the court, and a ward of the court is an imbecile. It's an infant or persons of unsound mind. Black's Law Dictionary, 4th edition. A ward of the court's an imbecile. A ward of the court is not competent. Everything is about competence and incompetence. That's why they're representing you, because you're not competent to make decisions for yourself. Therefore, the attorney's going to make them for you and sell you down the river so he can collect a royalty. There's no such thing as an incompetent sovereign. Do you know who you are? Impropria persona, in one's own proper person. It is a rule in pleading that pleas to the jurisdiction of the court must be pled in propria persona, because if pleaded by attorney, they admit the jurisdiction. As an attorney is an officer of the court, he's presumed to plead after having obtained leave, which admits the jurisdiction. And that's Black's Law Dictionary, 4th edition. So you hire, or they assault you with one of their baal priests. They assault you with their jurisdiction. That's exactly what these Satanists do. And this is all coming from the UN. See bar members' videos 1, 2, and 3. We can't even begin to count the number of times judges, lawyers, and statesmen has said there isn't any common law anymore. It has been replaced by statutes. They would be more truthful if they said there isn't any common law anymore. It's been replaced by martial law. And that's actually taken from a non-ratification of the 14th Amendment by Judge A.H. Ellett, the Utah Supreme Court, in the case Diet versus Turner. In the meantime, civil law was the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Why do you think they call it rules of civil procedure? Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens with martial law as opposed. If equity is a law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place. Again, that's non-ratification of the 14th Amendment by Judge A.H. Ellett, Utah Supreme Court, in the case Diet versus Turner. And this is the DC. No, this is the Judicial Code of 1911, located at 36 Stat 1087, and an act to codify and revise and amend the laws relating to the judiciary. In Section 9, it says the district courts as courts of admiralty and as courts of equity. And so That's all they are. That's at 36 Stat 1088. Chapter 2, District Courts, Jurisdictions, Section 24 at 36 Stat 1091. The district court shall have original jurisdiction first, and we'll just read the underlined parts. No, we'll read the whole thing. Of all suits in civil nature at common law or in equity brought by the United States and arises under the Constitution and the laws of the United States or treaties under their authority, or is between citizens of different states, or is between citizens of a state and a foreign state, citizens or subjects. No district court shall have cognizance of any suit except upon bills of exchange. That means they pay you IOUs, okay? So don't ask for anything but IOUs. Federal Reserve notes to recover upon any promissory note or other chosen action. Third, of all civil causes of admiralty and maritime, saving to suitors in all cases the right of a common law remedy where the common law is competent to give it. So what these bail priests do is they fabricate evidence of their U.S. citizen slave, which puts it into admiralty, and then they can collect their royalty. So that's exactly what they do. That's what I was in the Supreme Court here over within the last 6 months. The international law rule. This is taken from the jurisdiction over federal areas within the states, the report of the Interdepartmental Committee for the Study of Jurisdiction over federal areas within the states, Part 2, a text of the law of legislative jurisdiction submitted to the Attorney General and transmitted to the President in June 1957. This is page 158. International law rule adopted for areas under federal legislative jurisdiction, federalizes state civil law, including common law. The rule serves to federalize not only the statutory, but the common law of the state. That's on page 158. The same document goes ahead on page 165, and it talks about state and federal venue discussed. The civil laws effective in an area of exclusive federal jurisdiction. That means if you're a U.S. citizen, it's anywhere. Are federal law notwithstanding their derivation from state laws. And so that's all state statutes are actually federal. And this is Alberto Gentili, who was recognized as the founder of the science of international law. He was born in 1552. He was in office as the Regius Professor of Civil Law at I think it's Oxford. Anyways, was the earliest writer on public international law. The first person to split secularism from canon law and Roman Catholic theology. So it's all coming from the Roman cult. That's the point I want to make. There's 2 states in every state. There's a lawful state. There's a federal territory. There's been a created fictional federal state of XXX within a state, and that's C. Howard versus Sinking Fund of Louisville, U.S. Supreme Court, and that's cited in Schwartz versus O'Hara Township School District. The exclusive jurisdiction of the United States, having forts and dockyards ceded to them, is derived from the express consent of the state by whom the cessions are made. It could be derived in no other manner. So this is actually unless you're a U.S. citizen, okay? Otherwise, they don't have a shred of jurisdiction. They just fabricate evidence of that U.S. citizen. Slave is what they do. It's well-established principle of law. Federal regulation applies only territorial jurisdiction of the United States. There's a canon of legislative construction that teaches Congress that unless a contrary intent appears, legislation is meant to apply only in territorial jurisdiction of the United States. All they do is fabricate their evidence of their slave, their U.S. citizen and interstate commerce. State citizens are the only ones living under free government whose rights are incapable of impairment by legislation or judicial decision. State citizenship is a vested substantial property right, and the state has no right to divest or impair these rights. The state cannot diminish the rights of the people, and so it cannot be impaired by legislation or judicial decision. That's the U.S. Supreme Court. In other words, when state martial law is imposed within the state to enforce national martial law, Congress has no reason to exercise its martial law powers. That's why all the state laws are actually federal. They're enforcing the federal martial law is what they're doing. If a state has conformed to the new order, there's no need for Congress to intervene. And if a white citizen has not obtained the standing of a former slave by petitioning Congress for admittance to venue and jurisdiction of the 14th Amendment, then Congress has no power of that individual under this clause. And so that's Diet versus Turner, okay, non-ratification of the 14th Amendment by Judge A.H. Ellett, Utah Supreme Court. And this is taken from the causes and necessities for taking up arms. Statutes have been passed extending the courts of Admiralty and Vice Admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law instead thereof, to publish and order the use and exercise of the law martial. So, I mean, this is all through this presentation. They supersede common law and impose martial law, and that's been going on. It's what precipitated the War of Independence, and it's happening today. He's combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation, for imposing taxes on us without our consent, for depriving us in many cases of the benefits of trial by jury. This is all evidence of martial law during the War of Independence. It's happening again today. And this is the same one about the causes and necessities for taking up arms. And so they go and drag you into their kangaroo court, a term descriptive of a sham legal proceeding in which a person's rights are totally disregarded, in which the result is a foregone conclusion because of the bias of the court or other tribunal. And that's Black's Law Dictionary, 6th edition. It's a bill of attainder. All these statutes are bills of attainder. Means legislative act, no matter what their form, that apply either to named individuals or to easily ascertainable members of the group in such a way as to inflict punish on them without a judicial trial. There are no judicial trials. That's U.S. Supreme Court. And this is more stuff. Black's 8th on bills of attainder. A special legislative act prescribing punishment without a trial for a specific person or group. And the Bill of Pains and Penalties is though similar to a bill of attainder, prescribes punishment less severe than capital punishment. And so it's all unconstitutional. No one is bound to obey an unconstitutional law. No courts are bound to enforce it. An unconstitutional act is not law. It confers no right, imposes no duties, affords no protection, creates no office. It is in legal contemplation as inoperative as though it had never been passed. An unconstitutional law is void and as no law. An offense created by it is not a crime. It never became a law and was as much a nullity as if it had been an act or a declaration of unauthorized assemblage of individuals. And so these clerks, masquerading as judges, are operating in their private capacity. These whores, these UN whores, all oaths must be lawful, allowed by common law or some statute, if they're administered by persons in their private capacity. So they can be in their official capacity or private capacity. Well, they're not in their official capacity. They're in their private capacity. And so that's the point I want to make. That's Tomlin's Law Dictionary, 1835 edition. And then Brookfield Construction Company versus Stewart, an officer who acts in violation of the Constitution ceases to represent the government. And so, again, they're operating in their private capacity. Officers of the court have no immunity when violating a constitutional right, for they're deemed to know the law. Judge loses his absolute immunity from damage actions only when he acts in clear absence of all jurisdiction or performance of an act which is not judicial in nature. When enforcing mere statutes, judges of all courts do not act judicially and thus are not protected by qualified or limited immunity. And so other videos, and this is a little advertisement I'm putting in here because there's more to this. But I've got a bunch of videos that you might want to check out if this is of interest to you. Bankster Thieves 1, 2, and 3, Churchy Entity Series, Bankrupt Corporate So-Called Governments, Bar Members 1 and 2, Unidroit, Martial Laws here, Quasi-Contracts and Roman Civil Law, De facto courts, all courts are ecclesiastical courts, DC courts in Texas, and jurisdiction. There's over 260 videos, and if you want to learn about how the law works, then I suggest you check them out. So back to the original discussion. Anyone who's wearing a military uniform is an agent of the Roman cult. The wearing of clerical dress or religious habit on the part of layfolk is liable to the same penalty on the part of the state as the misuse of a military uniform. And that's Article 10 of the Concordat of 1933 that was signed by Hitler and the Roman cult. Almost all so-called governments are bankrupt and owned and operated by the Roman cult. At common law, a sheriff would have a star only and a judge would wear a business suit. At common law, there is no uniform. That's why in the old days they never wore uniforms. The following are Baal priests in the Northern District of Texas and the Arizona District and the Courts of Appeals for the 5th Circuit and the 9th Circuit. These are the whores I've had to I've dealt with that I have pictures of. And that's Sydney Fitzwater, the whore, Joe Fish, the whore, Terry Means, the whore, Samar Cummings, the whore, John McBride, the whore, Paul Stickney, the whore. See their Baal priest uniform? See that black robe? That's his Baal priest uniform. Edith Jones, the whore. See her Baal priest uniform? And there's the Supreme Court whores and their Baal priest uniforms. And then Baal priest, the Roman cult whores that I dealt with that I don't have pictures of them is Jeffrey Curtin, magistrate whore, Neil V. Wake, a judge whore, Reed O'Connor, a judge whore, Sam Cummings, a judge whore, Richard C. Tallman, a judge whore, Stephen McNamee, another judge whore. And the Code of Canon Law, Tribunal of Second Instance. All so-called courts or tribunals except the common law juries of peers. Trial by jury is not a trial with jury. It's all admiralty. All tribunals come from canon law. They assault you with their satanic contract to sell you into slavery. Recently, there was a news item saying that they're thinking about nationalizing the Federal Reserve Bank. That is nothing but a bunch of crap. The United States is already owned and operated by the Roman cult through the International Monetary Fund. Why do you think there's fascists in Congress beside the podium? That's showing that it's the Roman cult. That's Roman cult symbols all over the place. It is like taking it from one pocket and putting it into another. It's typical lies and fraud that the Roman cult Satanists like to engage in for the gullible idiots out there. These United Nations Roman cult Satanists convert a court case into a commercial transaction. They convert an Article 3 judge into an Article 1 revenue officer, Baal priest clerk masquerading as a judge who's working for the crown and the Roman cult. They pay for the errors when you file the filing fee. When you pay the filing fee, that's what it does. All of these things. It pays for the errors and omissions insurance for the Baal priest so-called judge, alleviating him of any responsibility in the matter. It's now a commercial transaction. Makes it so the Baal priest so-called judge doesn't care what the outcome is. It nullifies the Baal priest's oath of office in the matter since all errors and omissions are covered by the insurance. It converts a court case into a contract dispute in Admiralty, makes it so the Baal priest gets to collect a royalty in the case in support of his multi-million-dollar retirement, gives the Baal priest a special motivation to dismiss the case, to thereby encourage more violations and create more business down the road, creates business for his Baal priest buddies in the courts of appeals, creates the opportunity to leverage the fees by 30 times, since all courts are banks, to improve the balance sheet of their so-called court and generates revenue for their Roman cult handlers. Some examples of United Nations agencies is Child Protective Services, Family Court. All bar members are agents of the UN. All LEOs are agents of the UN. Anyone with a military uniform on. All of these whores have the capability to operate as an Article 3 judge, but none of them ever do. They fabricate evidence of the U.S. citizen slaves so they can put the case into interstate commerce under the Commerce Clause, convert it into an admiralty proceeding, and become a clerk masquerading as a judge. Then they can sit there and play stupid. They can collect a royalty in support of their $1 million retirement and perjure their oath and get away with it. That's what these Satanist Baal priests do. Anyways, to sum this whole thing up, copies of these documents can be found in my private group at Yahoo called Administrating Your Public Servants. I have YouTube videos that are videos of private information shares that show these and other court citations that are available for a donation. And this last paragraph is for all the Satanist order follower revenue officers operating in their private capacity under the Federal Tax Lien Act of 1966. They can put their privileges and benefits up their rectal orifice. Donations to support this work are appreciated, but I prefer a gold or silver coin. But as an extremely less desirable alternative, I can accept IOUs, Federal Reserve notes, PayPal gifts, checks, money orders, etc. Send me an email for particulars. My contact information is my blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email is engineerwin@yahoo. My YouTube profile is Sovereign Living and Sovereignty International. I've got two of them now. My Facebook community page, I deleted it because of censorship on the part of Facebook. My private group, Sovereignty International, is being deleted, but it takes a while to ban 17,000 people. And so, but I'm working on it. My Yahoo private group is Administrating Your Public Servants, and my Google private group is Administrating Your Public Servants. I appreciate you taking the time to watch the video. I hope you got something out of it. I hope you got the fact that all these courts are UN courts, and they're baal priests. They're clerks masquerading as judges. They're whores. Anyways, I appreciate you taking the time to watch the video, and have a real nice day.